रहीम व्यूअर्स, मैं शेख आसिफ एडवोकेट आपके सामने एक लेटेस्ट वीडियो के साथ हाज़िर हूँ। आज का हमारा टॉपिक है लॉ स्टूडेंट्स के लिए और उन तमाम लिटिगेंट्स के लिए भी जो किसी न किसी सिविल सूट जिन्होंने फ़ाइल किया हुआ है, और वह तमाम वकला जो सिविल प्रैक्टिस के साथ वाबस्ता हैं। एक टर्म यूज़ होती है इंटरम इंजंक्शन और एड इंटरम इंजंक्शन। इसमें आज हम आपको डिफरेंस बताएंगे कि इसमें इन दोनों में आपस में फ़र्क क्या है। तो व्यूअर्स, नाउ इट कम्स टू आवर टॉपिक। एन इंजंक्शन इज़ ए जुडिशियल प्रोसेस whereby a person is required to do or restrain from doing a particular act or a wrongful act. The grant of injunction aims to restore the violated rights of the party or parties. It follows the principle of natural justice, equity and good conscience. A court, normally civil court, possesses the power to grant interim relief during the pendency of the suit, the primary purpose being the prevention of property in dispute till legal rights and conflicting claims of the parties before the court are adjudicated. Injunctions are divided in two kinds. Number one, temporary injunction, and number two is permanent injunction. Now we first discuss about temporary injunctions. Use grant of temporary injunctions under provisions of Order 39, Rule 1 and 2 of the CPC were also to be governed by the principles laid down in Section 52 to 51 of the Specific Relief Act 1877 under Chapter 19, Section 53 of Specific Relief Act, that is 1877. Temporary injunctions are such as are to continue until a specific time or until the further order of the court, and they may be granted at any stage of a suit, which are regulated by the Code of Civil Procedure 1908. Now viewers, a temporary or interim injunction restrains the parties or a party temporarily from doing the specified act and can be granted only until the disposal of the main suit or until the further orders of the court. Now here Section 94C of the Code of Civil Procedure contains the provisions under which court may, in order to prevent the ends of justice from being defeated, grant a temporary injunction. It is regulated under the provision of Order 39 of the Code of Civil Procedure and may be granted at any stage of the suit. Viewers, the court shall, while granting a temporary injunction to restrain such act or to make such other order for the purpose of staying and preventing the wasting, damaging, alteration, sale, removal of dispossession of property or dispossession of the plaintiff or otherwise causing injury to the plaintiff. Temporary injunctions can be granted during the pendency of the suit on the basis of status quo, prima facie of the case and balance of convenience. Viewers, temporary injunction Order 39 Rule 2 can be granted on the term of the prayer for permanent injunction in the suit and not on different terms. Now the question is, under what circumstances interim injunction may be granted? The very important question. Use interim injunction of maintaining status quo against transfer of property, disposal of goods, making construction, affecting recovery of dues, attachment of property, appointment of receiver against prosecution, etc. can be granted. And on the other side, the question is, under what circumstances interim injunction may not be granted? Viewers, a relief of injunction may be refused on the ground of delay, laches, or acquiescence, or where the applicant has not come to court with clean hands, or has suppressed material facts, or where monetary compensation is adequate relief which is given under the law. Rule 1 of Order 39 of the Code, that is CPC, provides that wherein any suit it is proved by affidavit or otherwise that any property in dispute in a suit is in danger of being wasted, damaged, or alienated by any party to the suit, or wrongfully sold in execution of a decree, or that the defendant threatens or intends to remove or dispose of his property with a view to defrauding his creditors. The court may, by order, grant a temporary injunction to restrain such act or make such other order for the purpose of staying and preventing the wasting, damaging, alienation, sale, removal, or deposition of the property as the court thinks fit and proper until the disposal of the main suit or until further orders of the court. Now viewers, we have discussed permanent injunction. As per law and as per CPC, a permanent injunction restrains a party for forever for doing the specified act and can be granted only on merits at the conclusion of the trial after hearing both the parties in the suit. The permanent injunction permanently prohibits a person to do certain actions, while a permanent injunction, also referred to as perpetual injunction, which is one that's delivered at the time of the ultimate judgment. Now, the question is, when can a permanent injunction be granted? A permanent injunction may be granted to the plaintiff in a suit to prevent a breach of an obligation existing in his favor, whether implicit or explicit. However, in a case where such an obligation arises out of a contract, the court follows the rules as specified by Chapter 2 of the Specific Relief Act 1877. In the last, the most important thing which I want to tell you is temporary injunction, or in other words, we call it interim injunction, and number 2 is permanent, which is also called as ad-interim injunction. Hope you understand the instant topic on the subject. If any query regarding today's lecture, you can write the questions in the comment section of this video. We will try our best to answer as early as possible. Thank you so much.